Okay. Okay. I think we were back on redirect with Mr. Rankine. Are we ready for the jury, everybody?
Yes, sir.
Okay, let's have the jury. Welcome back, everyone. Please be seated. Okay, redirect examination, Mr. Conrad.
Thank you, Your Honor. Good morning, Mr. Rankin.
Morning.
Just have a couple of follow-up questions for you. So yesterday, Mr. Bertzer asked you about kind of the timing of certain things, whether you could remember the timing of certain things. I think he specifically asked you about how long you were on scene until fire arrived. You remember being asked those questions?
Yes.
Okay. And you indicated that you didn't know. Right?
Yes.
And why is that?
It's the situation with Mr. Ellis was very stressful. It was very dynamic. It's just hard to judge time at that time.
Okay. So you didn't want to guess at time, right?
Right.
And I want to see if there are some exhibits that we can take you through to try and establish some time frames. Are you familiar with a CAD report?
Yes, sir.
Okay. What can you tell the jury what a CAD report is?
So a CAD report is basically like an electronic generated copy that dispatch makes. Anything from radio calls to inputs from dispatch to our inputs, it all gets populated in one report so we can see via timestamp what all is going on.
Okay. So I'm going to hand you what's been marked as Exhibit 17. Is it Exhibit 17? Can you take a look at that document for a second? Is that the CAD report in this case, for this matter?
Yes, it is.
Okay. And how can you tell that?
It has the location, the incident number, the time, and the date of when it happened.
Okay. And so tell us about some of the information and how it gets input in there.
So there's, like I think I said just now, there's many ways you can input it. It's every time we key up our hand mics or our radio mics, it populates through dispatch. Dispatch can also input information in. Yeah, there's many ways. Your computer, our in-car computer, we can input stuff into the CAD as well.
And is that something that you all rely upon as well?
Yes.
And is Exhibit 17 a fair and accurate depiction of, or depiction, a fair and accurate document for the CAD report in this case?
Yes.
And Your Honor, I'm going to move for admission of Exhibit 17 this morning.
Any objection? Sure.
Your Honor, we do object, contains hearsay and issues with respect to the timing on it.
Respect to the timing?
Some of the times on it, in terms of the accuracy of the times, for the reasons that Mr. Rankine just stated.
Well, in order to sort this out, I think we're going to have a conversation outside the presence of the jury. Sorry, gentlemen, ladies and gentlemen. We're going to excuse you for a few minutes while we have this talk. Thank you. It's a little different format than I'm used to seeing, but I gather there's no issue as to authenticity or anything.
No, Your Honor, but like, I didn't want to say it in front of the jury, so I said hearsay, but for example, it contains criminal history information, run information with respect to Mr. Rankine. It wouldn't otherwise be admissible. On page 3, among other things, so.
There's a number of redactions here. These are identifiers, right?
Correct.
That's my understanding.
Okay.
I have no objection to redacting that portion of the CAD as well. And the timeline that's been shown to the jury multiple times as an illustrative exhibit is that, I think it's 896, is that right? The timeline, 898, and that's built off of this CAD timeline. This is computer generated by dispatch.
And I also want to clarify, Mr. Conrad offering this for substantive evidence as opposed to for illustrative purposes.
Well, I think he's offering for substantive purposes.
I think it needs to go back to the jury because it has the actual time frame for the jury. And right now, all the jury has is illustrative exhibits per time frame.
Yeah, the hearsay stuff we could take out. I don't see much problem with that. But you said you had an issue with the times?
Yes, Your Honor.
Times
I mean,
weren't accurate?
Just like we did when we established on 898, which was the illustrative. It's misleading to say that these times necessarily correspond, for example, to when a particular person arrived. And that's because it just depends on how the information is entered. So you'll see on here there are a number of people who were at the scene, who, for example, didn't put in a time that they arrived, and that we know that they were there. Other people who didn't put in that they arrived until later. People who came and went, etc. So there's just a lot of information in here that isn't necessarily representative of who was at the scene at what particular time. So that's also a concern from the state's perspective.
And I don't disagree with that. And actually, that's going to be my next line of questioning to illustrate that the time that they input something into the CAD doesn't necessarily correspond to the time frame that the person is on scene.
I think that's already been testified to. I don't mind you asking them again, I suppose, but have you guys taken a look at Exhibit 898 to see whether or not you could agree to admit it substantively? Will that solve the problem?
It might, but there's, within 898, that just shows the arrival time of various officers. I don't have any issue with admitting 898 as substantive as well. But there are other time frames in there that are contained in the CAD that aren't contained in 898. Like when fire is called, when they're updated, and that's not hearsay.
I also note a couple of things. First of all, I think that there's a lot of information on here about after the incident.
I'm sorry, about after the incident, did you say?
After the incident, right? After Mr. Ellis is dead, and a variety of other things that kind of follow that aren't relevant to these. But also the
Where does that start?
essentially on page 3, Mr. Ellis was declared dead no later than 12:02. So you'll see Jason Youngman arrives. He's arriving with a fingerprint scanner, but he's actually already, being treated with respect to by fire. I'd also just note that, the court did sustain the prior objection when I offered the CAD for fire stops, exhibit number 13. And as I understood it, the court was concerned about this issue about whether or not the information contained on the CAD is necessarily fully accurate. And that's the objection to 898 as well. Again, you saw how it's being used. We used it specifically to show just what CAD entries said about what time people arrived. In fact, there are 3 people on there that aren't even listed on the CAD, as I just noted. And then defense has been suggesting that certain people showed up at certain times, using that repeatedly to say Sergeant Lynn was there at this particular time. And again, it doesn't necessarily reflect that Sergeant Lynn was there at that particular time. He can say he's arrived as he's driving up and before he actually comes up to the incident. Other people, for example, Lucinio and Sanders, I believe they show much later that they arrived, but based on, some of the testimony, they would have arrived before, or at least what they said in prior statements, they arrived before Sergeant Lynn did. So there's just a lot of information that I think is not accurate in the CAD in terms of what the actual facts are for the jury.
Well, if my memory is correct, they showed it to a witness, Officer Ford, who wasn't familiar with it, hadn't seen it, and hadn't reviewed it. So that was the issue with it, offering it at that point.
It did come up during the, Exhibit 13 did come up during the testimony of Officer Ford.
It did, and he said that was the CAD related to the prior incident, to the prior stop, and he read through some times from it. He recognized it, no different than Officer Rankine in terms of what his knowledge would be about a CAD. So, it's a different foundation.
Well, one of the things that was different there was it wasn't a stop that Officer Ford was at.
It was.
Well, he showed up.
Right, but that's what the CAD entry was about that. That's what I was asking about.
But it was-
The time that they arrived and that they cleared, and he said that they did arrive, they didn't get out of the car, they saw Officer Collins or Officer Burbank kind of give them the thumbs up and say that it was okay, that they didn't need any backup, and so they drove on. And that's what he testified about.
And Judge, I'm fine with further redactions as to the event marks regarding the license inquiries. I think that can all be out. I don't know if the state's proposing other redactions.
Well, there's a whole bunch of stuff now. The bottom of, I guess it's the 3rd page, it's 23028. All these citation things that are in
Yeah, those should all be out.
here. To 23030, that goes on for over a page. I'm not sure what else would be here. All right, well, the hearsay should be redacted about that. The rest of it can come in for whatever it's worth.
Report reconsider that on exhibit 13.
You'll have to, we'll have to come up again and go into Exhibit 13's about. I don't remember all the ins and outs of that particular deal. That was on November 15th, after all. So, 3 weeks ago.
Hand that up to the court. You can show the court. It's exactly the same thing. It just happens to relate to the prior stop.
Anyway, so 17 can be admitted subject to further redaction. Oops, I guess I'll give this
And the
back.
court is, we're going to redact after that entry at 23, page 3. Everything else after that is out.
Oh, I wasn't saying that. I was saying that particular entry is out. I don't know about the rest of it.
The rest of it is not related. I mean, it's all, again, things that happened.
I hadn't been police officer.
That happened after Mr. Ellis had already died.
It may still be relevant, I suppose. I don't know.
Judge, do you want, I have a comment to tell us up and indicate where you want us to redact as well.
Well, the question, I guess, should go to you at this point, Mr. Conrad, at line, at page 23030. After that long entry, which we talk about being redacted, is there anything after that that you think is pertinent to this case? If it's not, then I suppose we should eliminate it.
Well, it just shows what, I guess, what's being communicated, at least via the CAD, in terms of them shutting down all directions of Ainsworth. Indicates there's a request for a body core attempt, to have people go back and take that. I mean, I'm not opposed to redacting the rest of it, or just removing those pages.
Well, if you don't mind removing them, she wants them removed, then why don't we remove them? Is there anything else on here? It's got, and there's a number of things on here that may matter, but
I mean, yeah,
Maybe
I
not.
do see certain things that I think have been testified to as well, so they clearly matter.
I notice at page, I'll call it 32, the last two digits. This might be hearsay, I don't know, but it's near the bottom. It says event remark per TFD time of death 0020. It might be hearsay, I don't know. But anyway, if that's the case, then we would,
There's a lot of these other entries that are just not, I mean, unclear if they're even in any way related after that. So if you look on 33, you've got this Shandon, Wright, Lee, Halls. You've got Officer Sturr and Schneider being apparently dispatched to something there. You've got,
well, it tells them that they were no longer part of this incident.
well, that's actually not clear, I think, because there's all these other, I mean, we don't know what these things are. There's another location, 3701 South Pine Street. had to pull it out. And I think it's
Well-
confusing with respect to what any of that relates to after that entry on page 3.
I don't know. I mean, I don't know if anybody cares about this point because I'm not hearing you complain about it, Mr. Conrad. So are we talking about everything to the middle of 28 is in and everything after that is out?
I guess that works for me. I mean, unless there's specific, I'd prefer to just do specific redactions so it's a complete document that shows the seriousness of this nature, right? So that when detectives are responding, it gives context to all the testimony.
Well, what? I mean, to some extent, I don't know how much anybody can make heads or tails of this.
Okay.
For instance, and it may even be confusing, I suppose. That's maybe the nature of the event. But if I'm looking at page 3.1, and then near the middle of the page, at 47:55, it says event remark. LT9 dash body temp 96.7 40 minutes after TOD, time of death, I'm assuming. Now, I don't know if it's supposed to be 40 minutes earlier than that, which would be 7:55, but then we have this other time of death, which is 0020, that we talked about earlier, that's on the next page, which may be inconsistent with each other. Or maybe with some explanation it would make some sense, but it seems confusing. I don't know. Then that remark comes up again at 1:28:18. Higher up on page 32. Where again it says 96.7 degrees, 40 minutes after time of death.
Okay.
I don't know. Anyway, tell me why you need any of the rest of this. Otherwise,
For purposes of what I intend on doing on redirect, I don't.
all right, well, okay, so if we cut it off there at
02:23 event marker.
I guess,
From there, redact down and remove the other pages.
yep,
Okay.
that should solve the hearsay issue too, I think.
Okay.
So subject to that redaction? Are we ready for the jury to come back?
I'm ready.
Let's have the jury.
The clerk can indicate that it's admitted in a redaction form.
Yes. Any of the defendants have a comment about this?
No judgment.
Sounds good.
We're going to eliminate the last couple of pages or so of Exhibit 17, which are very problematic. And so, other than once those redactions are made, otherwise Exhibit 17 is admitted. Proceed. I did say 17, didn't I? Exhibit 17.
So, Officer Rankin, we're talking about kind of timing of certain things, and you have Exhibit 17 in front of you.
Yes.
And Judge, with your permission, I just want to publish the second page of that.
That's fine.
Okay. Can you do that? Okay. And so there's a number of entries contained on here, is that right?
Yes, sir.
And can you explain to the jury what, I guess, these different columns are and the entries in them, and how it indicates who's entering the information specifically?
Yeah. So if you look at the far left,
Sorry. Judge, with your permission, can Officer Rankin stand up and then show the jury if
Sure.
Can everyone see?
I need to move the screen and tilt it again or not.
start left to right. Far left here is the date, so 2020-03-03. Gives you the date. That's the timestamp when everything's input. That gives you basically dispatch en route, kind of gives you what the activity is. Call signs, so Henry 031, that's my call sign with Officer Ford, which that's what gives us our identifier here. And then it kind of gives us like a badge number up here.
And so when it indicates Henry 031 in this column, like we see here, does that indicate who's entering that information?
That would be us entering information.
And what about if it shows this PDO2? Do you know?
PDO2 dispatch, they all have different designations, but PDO2 is usually the South Primary Dispatch.
So that's one of the dispatchers
Yes.
entering that information.
Yes.
And how do they go about doing that?
Either it's called out on the radio, or usually it's called out on the radio and they input it in.
Okay. So for example, if you're saying to dispatch that you're arriving on scene through your radio, through your mic, and we saw PDO2, that would mean that the dispatcher is entering that based on your call out over radio.
Yes.
But if we saw that it was Henry 031, that would be you entering that information on your computer in the car.
Right.
Okay. And so, one of the things, can you indicate here, does it indicate here where it shows you, what time frame it shows you arriving at scene?
I think it's right there. This is when I believe Officer Ford, in-car computer hits arrive. That's a two-person car. We usually arrive on the computer and then arrive over the radio. So that's him inputting it in the car before he jumps out of the car.
Does that mean that that's the actual time that you are getting there?
That's as we're pulling up on the scene.
Okay. And so that's 23/24/19.
Yes.
Okay. And that's all I have for this exhibit at this time. If you could stay standing up for a second.
Sure.
And Judge, with your permission, I'd like to publish exhibit 434. I believe it's already been admitted.
I think so too, but let me check. 434 is admitted.
Okay.
You may proceed.
Thank you. If we could play it through, and then Drew's already heard that there's a time stamp up in the upper left-hand corner, right?
Correct.
And that indicates the time that's running pursuant to the state's expert in this video.
Right.
And can you stop it at the time frame that you see you and Officer Ford arriving on scene?
Sure.
Under 217 update when you're available.
Can you go, I just want to speed this up. Can you go to 23/24/34? That's fine, you can just go ahead.
Available.
Can't breathe, sir. Can't breathe. Guys, need help? Oh, yes, Mike, coming. Back, I'm coming.
Alright, traffic, Henry 21796 at Ainsworth, keep the area open, 2323.
around, come on, come around. Stop car.
Two ones on scene 24. Hey, someone bring some hobbles.
So is that you?
That is my car, and that's me running out the car.
Okay. And so that's at 23, 24, 36, according to the state's video.
Yes.
Okay. And with the court's permission, I'd actually ask that you write, if it's okay, if we could write down a couple of time frames on the whiteboard.
Sure. Not on this
Sorry, on this
particular
white
one.
piece of paper.
You have to flip it over.
Sure.
But those are the diagrams that Mr. Lewis made. Still there. You can remove those if you want. Give them to Mrs. Winnie.
We could do that. I think we figured it out. How's your handwriting? Not good?
Dicey.
Okay. Sure, I can handwrite it. What is it, 23?
24. 36.
Rankin arrived.
You want to move that somewhere so it's not in front of your client?
Sure. Is that accurate?
Yes.
All right. And then next I want to ask about if you keep playing, can you stop it and let us know when you see other officers arriving on scene?
On scene 8 Adam or Ainsworth.
Thank you.
I think the first car pulls up, kind of in that intersection over there, and then two other cars pull up and block off the intersection.
Okay. And what's the time frame there?
23, 24, 54.
Is that accurate?
Yep.
And do you know who those first officers are that are arriving on scene?
I think according to the CAD, it's Sergeant Lim and I think Lieutenant Messino and Sergeant Sanders.
Okay. Next, I want to show you the pre-hospital care report. And Judge, this has already been admitted into evidence as well. It's 24. You take a look at that. When you look at this, you look at this second page there, I believe. Oh, third page. I didn't know it's front to back. What's the time that's indicated as fire arriving at scene?
Says 23, 33, 09. According to this.
23, 33, 33?
Yes. Oh no.
And what does it indicate on scene?
Yes.
And you indicated that you believe this is Sergeant Lynn, right? Or
Yes.
Lieutenant? No, it's Sergeant, right?
It's Sergeant Lynn.
So from the time period that you arrive on scene to the time that fire arrives on scene, given this information, are you able to tell us how long, are you now able to answer Mr. Pertzer's question about how long you were on scene? I know the math is difficult, but roughly.
A decent at math. 8 minutes, 30 some seconds, maybe,
Okay.
approximately.
8 minutes, around 8 minutes, 30 some seconds, is that right?
Yes.
So given this additional information, you're able to ascertain how long you're on scene now.
Yes.
Obviously, if I asked you that question without this information, you wouldn't know.
I wouldn't know.
Next, I want to ask you about the CAD again. I can take that back from you. What does it indicate on the CAD of when dispatch is told that you have that one is detained?
It looks like it's a dispatch input at 23:25:25.
23, 25.
Yes. 25.
What does it indicate?
One detained.
And what does it mean, one detained?
I think in this particular incident, I think this is when hobbles are placed on Mr. Ellis.
And so when we asked you about how much time had gone by between the time that you arrived and the time that hobbles are placed on, you weren't able to specifically tell us at that time, right?
No.
When you look at the CAD and you look at this information, the videos that we have now, does that help you in ascertaining what the time frame is?
Yes.
And so what is the time frame between when it's indicated that one is detained and the time of your arrival?
Less than 1 minute.
Okay. So why don't I indicate again, rough estimate. You don't have to do math. Right?
Yes.
So again, when you're telling the detectives about all the actions that you're taking, you're talking about a time frame that's taking about a minute in time, roughly,
Yes.
based on information that we now know.
Yes.
And after Mr. Ellis was placed into hobbles, how quickly was he placed into the recovery position?
Very quick.
And how long did he remain in that position?
Quite a while. I think for most of the time.
And do you remember specifically when he was placed back into the prone position?
Not off the top of my head.
It was sometime prior to Fire's arrival, is that right? And how long did he remain in that prone position?
Very little time.
And how much pressure were you putting on him when you put him back into that prone position?
Only enough pressure to control him. I would say it's a reasonable amount of pressure. My pressure fluctuated with his struggle with us. If he wasn't struggling, he was in a recovery position. If he was struggling, I put pressure just to control him, not to press him to the ground, nothing of that sort, just to control him.
And how did the fact that he was hobbled at that time frame when you placed him back in prone position play a factor into that as well?
Yeah, when he's hobbled, he was easier. I think I stated yesterday, he was easier to control. He wasn't doing that wiggle worm motion anymore. So for me, only one knee was needed to actually just kind of control him. I didn't need to put both of my knees on his back, just one knee to control his body.
And are you able to manipulate how much your pressure you're putting on him by changing where you're placing weight?
Yes. With my right knee being on the ground, kind of close to the shoulder blade area, I can modulate pressure back and forth, kind of what I demonstrated yesterday.
I want to show you one other exhibit as well, with the court's permission. Exhibit 435. As well.
It has.
Pause it there. Actually, can you go back to the beginning? Try it one more time. And are you familiar with this video?
I am.
That's the Miss Malang, formerly known as Miss White's video, correct?
Yes,
And
correct.
that's the one we went through on direct examination.
Correct.
And based on your view of this video and your memory of the event, what position is Mr. Ellis in at this point?
He would be in the recovery position at this point.
And what's your positioning in relation to him?
I think in this video it actually shows me I have no contact on him. I'm just kind of kneeling behind him. I think my hands actually are on my thighs, and I'm just kind of looking at him and then looking around.
Okay. And what's the time frame here?
23:32:06.
Say it one more time, sorry.
23:32:06.
I don't know how to spell Malay, so I didn't put it down. Say it one more time. A-N-G.
Correct.
So you know at this time frame that Mr. Ellis is at least back in the recovery position, correct?
Yes, sir.
And in relation to when fire arrives, that's roughly how long?
I think according to the dispatch, it says they were on scene at 23:33 and some seconds.
Okay. So this movement of putting him prone and back to recovery has already occurred at this point.
Yes.
And did you have any of this information available to you at the time that you did interviews with the detectives of Pierce County?
No.
Had anyone shown you any of this information?
No.
Okay, you can have a seat now. Thanks. And we can take this down. I'm going to ask you about a couple of
Okay.
About the hobbles. Have you ever used a hobble before?
No.
Had you ever carried hobbles in your vehicle leading up to this incident?
No.
And had you ever dealt with an individual that had been placed into hobbles?
No.
Did you ever ask for or request hobbles in this case?
No.
Next, I want to ask you about the spit hood. And I believe on cross-examination you said that you recall the spit hood, right?
Yes.
But you don't recall at what point it was placed on the show.
I don't. It's very vague.
And part of, were you ever asked about that during your interview with detectives that we've gone through?
I was not.
And how does that contribute to your ability to remember when it was placed on you?
I barely remember it at the scene, just because the scene was just so dynamic. And because I wasn't asked during the interview, yeah, my independent recollection of it's pretty vague.
And how many years has it been since this incident?
3.5 years, going on 4.
And have you ever used a spit hood before?
I have not.
Have you ever carried a spit hood in your car?
I do not.
Have you ever been trained on the use of a spit hood?
I have not.
Have you ever been trained on the use of a hobble?
No.
Have you ever dealt with an individual that had a spit hood on?
No.
Did you ask or request for the spit hood in this case?
No.
Last couple of questions here I have for you, officer. I want to talk to you about, Sergeant Lim being on scene. Sergeant Rock was on scene as well, is that right?
Yes, sir.
And Ms. Eeks actually asked you in cross-examination about multiple other officers being on scene at that point. I think she estimated anywhere from 13 to 20 officers.
Yes, sir.
Where in the seniority ranks were you amongst those other officers?
I think I was one of the most junior officer on scene.
And if you had been doing something that was not in line with policy or training, would you have expected another more experienced officer to help you out in that way?
I'm going to object. It's false speculation.
Overruled, you may answer.
Absolutely.
And did anyone at any point help you or correct you in what you were trying to do?
No.
When we talked about your partner, Officer Ford,
Yes.
is he more senior than you?
He is.
And can you describe to the jury what it means to be partners with someone on scene, how you coordinate?
Well, me and Officer Ford, we worked very well together. During this whole incident, he was right there, right by my side. So if that was anything I was doing inappropriate, if Officer Ford saw it, he would have spoke to me about it, and I would have corrected it.
And Officer Collins testified, and he used this word, Rolodex of experiences. Remember that?
Yes.
I'm going to ask you about your Rolodex of experiences as a police officer.
Okay.
Prior to this incident, had you ever dealt with anyone that you believed might be experiencing excited behavior?
No.
Had you ever dealt with anyone in a situation specifically like this?
No. Absolutely not. This call, I've never had a call where multiple agencies showed up. 4 agencies showing up is, yeah, that's the first time for me.
And in the 8 minutes that you were there prior to fire arriving, did you do your best?
I did.
How many times did you place Mr. Ellis in the recovery position?
Twice, and I think I previously testified. I tried to keep him in the recovery position as much as I could.
Did you check him for injuries?
I did.
Did you reassure him with Officer Ford to keep reading to remain calm.
I'm not gonna object to reading.
It's leading.
What did you, and Officer Ford, say to Mr. Ellis during the time period that you were there?
We kept telling him to relax, calm down, stop fighting, just breathe.
Did you take his pulse?
I did,
How many times?
twice.
Did you remove the taser probes from him?
I did.
Did you ever punch Mr. Ellis?
No,
Did you ever kick Mr. Ellis?
no,
Did you ever hit him in any way?
no. That would have been inappropriate.
Did you ever cuss at Mr. Ellis?
No.
And when fire arrived on scene, I want to ask you about what you stated in your statement. This is State's Exhibit 65A.
Thanks.
You turn to page 19.
I'm there.
Sorry, page 20.
Okay.
Line 17. I want you to take a look at it. Refresh your recollection. I'm asking a question about it.
Okay.
When fire arrived, what was the first thing that you told them in response to their arrival next to Mr. Ellis?
What do you need from us?
I don't have any further questions. Thank you.
Recross.
Mr. Rankin, you gave a statement about this case on March 6th, 2020, correct?
Yes, ma'am.
And you knew at that time that Mr. Ellis had died,
Yes, I did.
and you understood that this was a death investigation into what had happened to Mr. Ellis on March 3rd, 2020, correct?
Yes.
And you had 3 days to be able to consider and counsel before you went in for this interview, correct?
Can you counsel? I don't know what that means.
You had other people with you in the interview, correct?
Your Honor, I'm absolutely heard.
Okay. Ladies and gentlemen, please excuse us. Please do not discuss the case.
I'm a bit perplexed, Judge. I don't know what counsel's now indicated, I think she's violated at least 2 motions in limine. One is not to comment on their right to remain silent during a period of time. It took them 3 days to come back and do interviews, and she's just now commented on that in 3 days. That he had time to seek counsel, so comment on his right to an attorney as well, which was another motion in limine. And then she's starting to go down a line of questioning and says, well, there was other people there with you at the investigation. I mean, I'm shocked that we've made it this far into this trial, and now we're going to create a mistrial in this scenario, because that's what I'm going to ask this court for at this point, given the comments of the people.
I think they're on.
Your Honor, I was not asking him about his right to counsel. I was asking him about the fact that counsel suggested that somehow when the statement was given by Mr. Rankine, that he didn't understand the importance of it, that he didn't have time to consider all of the facts that were given. And what I'm simply establishing is that Mr. Rankine knew that this was a death investigation. He knew it was being done by an outside agency, which is what I was going to ask him. That he gave the statement days after this particular incident. And he did have union representation. And he's not, the suggestion that somehow he gave this statement without really understanding the importance of it, or without having time to consider the facts or understand the gravity of it, I think is misleading. And that's all I'm asking about.
Well, you use the word counsel.
I believe what I was trying to ask him was whether or not he had time to consider and counsel himself before he was giving the statement.
Not counsel himself. It
Well,
was,
that's what I
counsel
was
was
asking
mean
about.
that others assisted him in how to respond.
Well, I
is
asked
what
the
you-
second question. Then I asked him about whether or not somebody else was present. If he had someone else with him.
What was the intent of, I mean, where were you going with that?
But he had the union present with him.
But why?
Why does that matter?
That's a motion in limine. If you needed to bring it up,
Trust the judge. With respect to having the union be present.
having a union attorney present there,
I didn't ask him about an attorney.
but you just asked him about counsel, that he had the opportunity for counsel.
One at a time.
It's absolutely inappropriate.
Hold on, Mr. Conner, let Ms. Eakes continue. Go
I
ahead.
was asking him about whether or not he had time to consider his actions and counsel himself before he gave.
It wasn't counsel himself, Ms. Eakes, with all due respect. It was not that.
That's what I was attempting to ask him, and I didn't ask him about having to understand that you can't say that, but then I was asking him whether or not somebody else was present. We can see in the transcript, and they can hear from the recording that there were multiple people present. And again, I'm only addressing.
Well, didn't we specifically redact those names and stuff so
No,
they
we
wouldn't
didn't
say that?
redact the names, we just redacted that it was a lawyer. But there are other people present when he speaks. That's the issue.
Well, can I take a look at Exhibit 55A,
65.
5A.
65A?
Yes, I talk to myself and say, things go
Ah, thank you.
We have it.
Is this the copy that we gave to
Yes.
jurors?
she's attempting to get a mistrial. She doesn't know how this case went, and this is her last ditch effort to save this case.
Right.
And blatant and
I'm baffled. I mean, honestly, baffled.
Mr. Myers' status is not identified on it.
Correct.
Does he ask any questions? I guess he does. Well, he just says for the record his name.
Oh, actually, yes.
Does he?
Yes, he does.
they don't get there for like 90 more seconds. That's what I said. He's like, a half hour. Yeah.
Is your mic on?
No.
And it's ours.
It is. The mic is on.
I don't see where Myers asks any questions. Maybe he did. You guys are more familiar with this than me.
I mean, Judge, what does that matter? It's not indicated as an
I
attorney. It's not
understand. Hold on a second. Let me just establish what the facts
I'm
are.
upset, and I think I have every reason to be.
I can understand that. My predecessor in this job was a guy named Tom Swayze. And Tom had a remarkable capacity for calming everybody in the courtroom when everybody got all worked up. I wish I had that now. In any event, one of the excellent things about Judge Swayze. Okay. Continue, Ms. Eakes, if you have more to say.
Your Honor, I think I've explained what I was asking about and the reason why I was asking about it.
All right, the reason, well, explain to me the reason why again.
I'm asking about the impression that was left by counsel that Mr. Rankine, when he gave the statement, somehow didn't understand the seriousness of it or didn't have all of the information. In fact, he even asked him whether or not anyone had shown him any of the documents related to it. And again, I mean, I wasn't going there, but I mean, personally, I think he opened the door with respect to the fact that he consulted with a lawyer. I mean, we don't know what documents he was shown, and it's, you know, to ask him and suggest that somehow he didn't actually have any information before he gave the statement, I think is misleading.
How is it misleading if you don't know what he was shown?
Well, you're using this as a sword and a shield, right? You know he has counsel. You know that he is prepared for it. We have every reason to believe that he had information at least from the CAD before he gave that, or I'd be surprised if he didn't. And then to suggest that, you know, somehow he went in there without any knowledge about what had happened or didn't understand the seriousness of it is what I'm attempting to ask about.
So if a defendant talks to the police about an event, and it happens that he's made the statement to the police after he's talked to his lawyer, would it then be appropriate to mention after he's testified about all this, by the way, you talked to a lawyer before you talked to the police? Would that be appropriate?
No, that's not what I was asking.
No, but I'm just asking for my sake. Would that be a problem?
No, not to ask him about it.
You couldn't do that, right? I'm wondering how much different this is. Mr. Usser, you're now standing. Have you got something to say?
Well, Judge, I'm at a loss because if Ms. Eakes actually believed what she's now saying, she would have asked to excuse the jury and addressed this outside the presence of the jury. She's a prosecutor who has an obligation to protect the constitutional rights of this defendant, and that defendant. You don't get up in front of a jury and suggest that you spoke to counsel and then try to convince this court I'm not talking about speaking to an attorney. That's... I'm trying to choose my words carefully. That's not credible, Judge. Ms. Eakes wants a mistrial because she doesn't like how this case has gone. And that's exactly what she just tried to do in front of this jury.
So you think this is a deliberate attempt?
Absolutely, 100% flagrant and ill-intentioned. You don't stand up and say, you had the right to counsel, you spoke to counsel.
I didn't say that.
You absolutely did.
Well, you came awful close to that.
Well, let's read back the transcript.
That's not what I asked, and I wasn't intending to ask that.
Let's read it back, Judge.
Well, and if she
Hold on, one thing at a time. If we're going to have it read back, you can't keep talking. Because the reporter, none of us, because the reporter can't do all these things at one time. Jessica's magical nearly, but not that magical. So I'll simply ask Jessica to try to retrieve the part where Ms. Eakes uses the word counsel.
Question.
Hold on a second. Let's read the question before that.
Off the record right now?
We can be off the record on that. Just for the moment, read the question before that question so we have a little better context, and then read that question. Read the prior question and answer. She lost her place because when I said, so she goes back to the, gotta find it again.
Question, and you heard that this was a death investigation into what had happened to Mr. Ellis on March 30th, 2020, correct? Answer, yes. Question, and you had 3 days to be able to consider and counsel before you went in for this interview, correct? Answer, can you counsel? I don't know what that means.
And you had counsel. You had 3 days and counsel.
Considering counsel before, and I believe there's a question after that, as I recall.
I don't know, there might,
And then the next question is, and there were more people at the insinuating that.
yeah. Okay. I do think it's a violation of one of the orders in limine with respect to the presence of Mr. Myers in terms of his status. If they didn't know before, which we took the pains to keep from the jury, now they do know he was counsel. So I think that's a problem. Now, what should I do about it? Are all the defendants asking for a mistrial?
I'm asking for dismissal, Judge.
Well, we're not going to do that. Your argument is it's an intentional violation.
Judge, and if it wasn't, she would have asked to be heard outside the presence of the jury, like every prosecutor's tried more than one case would have done.
Anyway, Mr. Fricke and Mr. Percher, what's your client's position?
Yeah, we'll join in with them. It's enough said, but we'll join in.
All right,
I oppose a mistrial, Judge, from my client's perspective.
you oppose a mistrial,
Absolutely.
but you want a dismissal instead.
Or let the jury decide.
Well,
Dismissal
if,
from my client, and if you're going to deny that motion, then we want to.
if I don't grant a mistrial and I don't dismiss it, then yes, we proceed to the jury trial. So anyway, you're not asking for a mistrial, though. You're asking for a dismissal on the basis it's intentional. Yes, go ahead.
Judge, we will join with Mr. Osher. We don't want a mistrial. The court has clearly granted mistrial to Mr. Rankine.
You also think it's intentional misconduct.
There's zero.
You want to say anything else about it?
There's nothing more I need to say.
Okay, but that I'm not going to make yet. Mr. Conrad, anything else?
I mean, I think it's a blatant violation, just as Mr. Oster says, it's, you know, if she didn't want to do that in front of the jury, she would have taken it up outside the presence and raised the issue. And this court has commented on that multiple times. When we were doing motions in limine, when we were preparing for this case, we even indicated to counsel, if you think that a door has been opened, the appropriate thing to do is to take it up outside the presence of the jury. You've specifically said that, Judge. At least I've been listening.
I've said it more than once.
And so counsel knows that. Ms. Eakes knows that. And if she felt that the door was open, she should have followed this court's instructions. But I agree with Mr. Oster. She doesn't want a mistrial in this case. She wants to just commit misconduct blatantly, intentionally. Otherwise, I mean, her explanation doesn't make any sense. It doesn't even pass the smell test to counsel himself. I mean, what? Counsel himself, it doesn't make any sense. And it's the court's found that it's a violation of the motion in limine, and I'm going to ask for a dismissal.
So you don't want a mistrial either? Because you said you wanted a mistrial.
I have to speak with my client who's currently on the stand. I can't make that decision.
Well, I'll tell you what, we'll take our morning recess this time, let the jury know, and you'll have an opportunity to consult.
state is we're going to move for dismissal under 8.3 for misconduct.
So you're not asking for a mistrial?
Well, I would be if the court's inclined to find that.
Is this a negotiation?
Well, I guess I'm wondering if the court's going to find that this was made in bad intent, ill intent.
You got to make your motion.
Well, I'm going to start with a motion to dismiss under 8.3 for misconduct.
All right. So we got a motion to dismiss from everybody, but not a motion for a mistrial. And two defendants saying we don't want a mistrial, I think. Okay. Ms. Eakes, your response.
Your Honor, I've already stated the questions. I mean, at worst, you've got one word that the jury heard based on what the court reporter read back to counsel. And I can certainly go back. It's not me, as I've already indicated, it was not my intent to ask about whether or not he had a lawyer. It wasn't my intent to try to suggest he did. I was simply trying to respond to the issue of whether or not he had time to consider before he gave his statement, and he understood the seriousness of the incident at the time that he gave his statement. Those were my questions. Certainly not a violation that, or an issue that the state believes would result in any sort of a dismissal. In the long course of things, it's unlikely the jury even understood the one word or what it means the same way that lawyers would. So, and I offer that, one way to cure it is I can go back and say, I had a poor choice of words. When you gave your statement 3 days later, you had time to think about it before you gave your statement. That's essentially all I was trying to ask. And that would address it, or the court obviously could consider whether or not you wanted to give some sort of other curative instruction. But I don't think there's any basis to dismiss the case based on that single word.
Okay, well. Oh, sure.
Council mentioned Rule 8.3, but there's also RPC 3.8, which discusses the role of a prosecutor to be a minister of justice and not simply have an advocate. That this responsibility carries with it specific obligations. This is the notes. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice and that guilt is decided upon the basis of sufficient evidence. That's their duty, Your Honor. They took an oath as prosecutors to make sure that these gentlemen received a fair trial. And by overstepping procedural rights or commenting on them to obtain a guilty verdict is simply wrong, and it's a violation of our rules of ethics. Now, you'll recall Ms. Nicolavo asked about one of our experts whether they were being paid by PORAC, which also was a clear violation of what is established rules of evidence relating to collateral sources. And it's cumulative, the actions of the state here. And now they're losing this trial, and they want a mistrial. And they're putting us in the Hobson's choice of either asking for something that's actually probably to our detriment or having to do it all over again. And that's not fair, Your Honor. We're winning the case. They know it, and they did this on purpose, just like they did it with the PORAC argument earlier, or PORAC statement.
I understand that obviously counsel has taken the position. There's no basis for the court to conclude, nor is it true that the state in any way wants a mistrial in this case, nor was making any sort of effort to meet our obligations as prosecutors. And I think that as the court has seen, we have tried to present the evidence as fairly and straightforward as possible, without any attempts to in any way violate the defendant's constitutional rights. So I think we take that very seriously as the state, and we have attempted to conduct ourselves in that way and only put on the testimony in the most straightforward way possible. So, the idea that somehow they're winning this case, I guess that's their perception. But obviously all we want is for the jury to be able to make the decision with respect to the facts.
Well, I'm sorry, you guys keep jumping up here.
Final word, Judge.
Okay.
The idea whenever you come into any type of case, you start with a level playing field and you work with it. It doesn't always work that way, but that's what often happens. The criminal rules set forth the procedures to follow for both sides, and they also give the court some latitude regarding how to address this is one of those issues. And 8.3 sets forth that the court has the discretion on the authority to dismiss prosecutions if there's been a violation. There could be probably a clearer violation of the motions in limine than what occurred here just now. I mean, it is ludicrous to suggest that the question was not asked for a particular purpose. It's simply ludicrous. It wasn't even close to what the counsel asked for purposes of dealing with Mr. Rankine regarding, did you know there was a video? He simply had no idea. He simply recounted what the events were. 8.3b talks about the court's motion to dismiss the prosecution. And what the court needs to show, or has shown to it, is there's been prejudice to the right of the accused, which materially affected the accused's right to a fair trial. And the idea is, well, is it a fair trial? When you throw in these gratuitous remarks, not only what counsel did previously with respect to Ms. Nicolavo, this reference regarding the payment, but for purposes of addressing that, you had counsel before you met with these folks. It's simply wrong. It's prejudicial. There's really no other word that you can use. The court has the authority and the ability to dismiss a charge. What it does to the defense is it puts us in the hostage joke that we are clearly in right now. Do we ask for a mistrial, give the state a chance to reload, try this thing over, or do we keep on going, knowing we've got this taint on the case? That's not fair to the defense in any fashion. It's not fair to the defense collectively because they're tried collectively. And so the damage that occurs to one individual, it impugns everyone. And so the court has the discretion and the authority to dismiss a prosecution when you have that type of an arena that occurs, as we have in this particular case. And so Judge respectfully urged, pursuant to 8.3b, that the court exercise the discretion. And understand it's a tremendously significant matter. But it's nothing that the defense brought up. It's something that the state brought up, and the state is the responsibility to prosecute the case fairly, and that is not happening. So Judge asks you, on behalf of Officer Burbank and also Officers Collins and Rankin, the court dismiss the case pursuant to 8.3b.
Well, can I ask you and Mr. Osser then, and I guess Mr. Urbans too, since he's spoken on this, how would misconduct as to Mr. Rankine's statement prejudice your clients?
Because all the court needs to do is think back to the redactions on our client statements. The same exact scenario is present. So the inference is all these guys had counsel. My client was interviewed on March 9th, 3 days after Officer Rankin. We have the same redactions that were handed out that are in Officer Rankin's. How do you unring the bell that you're suggesting that these officers had days to see counsel? Other people were present. We redacted that in the transcripts, and then I asked that question specifically. That applies to Officer Burbank. It applies to Officer Collins just as it applies to Officer Rankin.
It's a bigger leap on the facts, though.
Well, but it still prejudices. They've joined these cases. It prejudices this entire defense. Now, it certainly prejudices Officer Rankin more than Officer Collins, but there's no question this prejudices my client at all. I mean, now the jury's heard counsel and that there are other people present. Well, they heard this without the counsel comment. The same circumstance with my client only 3 days later. So they're going to go back and be like, well, if Mr. Rankin had counsel, so did Officer Collins, so did Officer Burbank. In fact, when we played the audio, we deleted out Attorney Staropoli as it related to my client, so they know there's a redaction. Of my client's statement, Attorney Staropoli actually asked questions, intervened, and so now they know he has an attorney present who's inserting himself into the interview. And I think the state wants them to believe that he's directed this interview with 6 days of preparation to craft my client's explanation of what occurred that just happened to match up identically with the video evidence that's later produced. So I don't know how it doesn't implicate Officer Collins.
Well, of course, I think it's been well established the video evidence wasn't available to anybody, or even known about, maybe even at that point in time. Maybe the Vivint video was known to Detective Brockway, but I don't think any of the other stuff was, certainly, we know that. Well, okay, I guess I'd say a couple of things. One, there's been a couple of comments like this on both sides of this case. You mentioned the one by Ms. Nicolavo earlier, and that was wrong. I agree, and said so at the time. We also had the comment, I think, I was supposed to Mr. Bull or Mr. Wolf from the Pierce County Sheriff's Office about after the 2019 event, Mr. Ellis was still alive and you dealt with him. That was really gratuitous and out of line, and I'm not sure what that was a product of, but I don't think at that point in the stage you could say the state was angling for a mistrial. The reason for the rule about this to some extent in terms of having a dismissal instead of a mistrial, the idea of it is that if the state is in a situation where they've got a likelihood of not prevailing, the court doesn't necessarily have to find this, but the thinking is that if the state feels like they're not going to prevail in something and they kind of want a do-over, well, they can't just say, we're going to dismiss the charges and refile, because jeopardy is attached and double jeopardy would apply, and they couldn't refile. So the argument of the defense is, in those circumstances, that the state intentionally does some kind of misconduct in order the court will declare a mistrial so they can get their do-over without jeopardy attaching. And if the state does that, or the court believes that the state has done that, the court should say what it is. I mean, you're trying to evade the constitutional right about double jeopardy. Now, I mentioned the idea that there have been some remarks on both sides. I think we gave Mr. Arbenz a shot for saying something previously too. I've done this kind of stuff for a long time, both as a judge and a lawyer. And when we're nearly 3 months into a trial, I appreciate that emotions get high and tempers get short and patience gets short. And we all get a little bit testy here. It's possible that the use of the word counsel in the circumstances was a misstatement by Ms. Eakes, but it just seems to me so that he was trying to counsel himself. I just think that's not credible. I don't think that's what happened here. I do think she mentioned counsel because in the spirit of the moment, she got trying to make a point. And substantially a tangential one, I guess I had pointed as that. She went too far. And so, yes, I do think it was a violation of the order in limine. But all errors do not make a mistrial or a dismissal. I don't think she did it for the purpose of achieving a dismissal. Because of that, I don't think there's any reason, or to achieve a mistrial, rather. And for that reason, I don't think there's any reason for the court to think the state did this in order to get a do-over, and therefore evade the consequences of the due process requirements of the Constitution. So I don't think a dismissal is justified, and that was pretty apparent to me immediately, just the way how this happened in the moment. But it was a little more than a misspeaking, certainly. Then the question is, no one's asked me before a mistrial, maybe, although it sounds like Mr. Conrad is hoping to keep one in his pocket. Are you making a motion for a mistrial or not?
I'd ask to reserve on that at this point. I'm trying to do my homework and look at the case law, and I want to make an informed decision. If the court's not going to dismiss it this time, then I'd ask to be heard maybe at a later date on that, so I can look at the case law. We can make an informed decision, very least, I'd ask for sanctions under 8.3.
What kind of sanctions are you talking about?
I'd ask that the state
forfeit the remainder of their cross-examination and not be allowed to add the additional lesser included of manslaughter in the second degree.
I don't think those are appropriate remedies. Do you want me to instruct the jury in some way to disregard the remark?
I don't. I want to stay far away from this area. I don't think it's even appropriate to start talking about you had 3 days to think about this, because it implies it.
Look, she's already gotten that in. I mean, the
Well-
question is, you did this, when did you do this interview? Well, this was the date. That was 3 days later. So that's in. I can't change that. And those are the facts. I'm not going to edit the truth here.
Well, I understand. Well, I'd ask to reserve ruling on the mistrial issue so that we can brief it.
Well, I'm not sure you can do that or not. I mean, I think you kind of have to make your motion or not. But if you don't want to make it at this time, I'm not going to force you to it. It may have some impact on whether or not we grant it later.
Understood.
You know, you just kind of,
Well, I don't think that there shouldn't be any remedy in this scenario, right?
Your Honor, if I might jump in, I'd ask them to take recess.
oh, I'm not going to do that either. All right. Well, I'm not hearing a motion, so I'm not going to move forward to have a discussion about that.
So, can we take one other brief recess for 5-10 minutes so I can talk to my client about this decision? I mean,
Well, that's what we took a break for over 15 minutes, so you could do just that.
can I have another 5 minutes for
I'll give you 30 seconds. Because it's not like this is anything new. We've talked about this now. It's time to make a decision or not.
I'll make the motion at this point for a mistrial on behalf of Mr. Rankine.
Any additional comments you would care to make in support of your motion?
Well, my read of the case law is that the court can declare a mistrial without us requesting it if the court feels that it's appropriate. And the court's alluded to this as well, that if the court feels that the prosecution is putting us in the predicament of essentially trying to retry this case or accepting a case that could be prejudiced, then a amounts to government misconduct. I don't think it needs to be intentional or even in bad faith for.
Well, I'll grant you, some mistakes are more serious than others, and it doesn't have to be intentional misconduct for the court to dismiss a case. I'll grant you that. But intentional misconduct for a dismissal is a suggestion that it was intentional to get a dismissal, to evade the due process requirements. That was the point I think Mr. Osler was making when he made his motion for dismissal in the first instance. I've already dealt with that. But anyway, continue. I just wanted, if I was unclear, I wanted to make that more clear. Anyway, so you made a motion for mistrial. Anything else you want to add?
Correct.
Nothing else? Okay, Ms. Eakes?
Your Honor, I think I've already stated before, but just, I mean, the court knows, I mean, we're 10 weeks into this trial, the jury's been hearing evidence for 10 weeks. And, you know, a single inadvertent word or, you know, in this particular case, at this particular junction, does not warrant any sort of mistrial. It can easily be cured to the extent the court thinks it needs to be cured. I mean, I would just say, most people don't even know what counsel means in terms of, it's not like I said lawyer. I mean, where most jurors and lay people might understand it.
I have to say, I think I've used the word counsel multiple times in the course of this trial, and, you know, jurors would have heard that, and it's clearly referencing the lawyers in the case. I mean, it certainly does have two meanings, but in the context here, it seems to me it could only have been a reference to a lawyer. But anyway, go ahead. I've already made that ruling.
Yes, and you have, but for those reasons, Your Honor, I don't think that there warrants any sort of mistrial in the case.
Okay, well, there's a natural sort of human emotional response that says, we've been on this so many weeks and months, we've done so much effort here, let's just get to the finish. And it seems to me that's a very dangerous way to think about this. Rather, you have to look at it and say, how serious is this in terms of whether or not the defense is actually has had the opportunity of a fair trial impaired, and any error that touches upon the invocation of a constitutional right is often considered on its face prejudicial. But I do think here that the mistake was not calculated to try to get a mistrial, one. Two, was sort of nipped in the bud by the motion that was made here. It didn't get to be so serious that I think that the defense has had is likely to have an unfair trial if we proceed with this. And I've offered another remedy like instructing the jury, which the defense has declined, I think. And I understand the reason why they declined it, because they don't want to emphasize the error that much more, which only can and sometimes exacerbate the error. So defense sometimes feels, when circumstances like this, that they're helpless at this. And I keep in mind as well this, which when we talk about the error of sort of saying how much time we have to, we've spent on this already and we don't want to just toss that over. Well, if the error is bad enough, we will do that if that's what we have to do. Not happy about it, certainly. One also keeps in mind the idea that somebody situated as the defendants are here have a huge financial stake of nothing else, never mind their liberty interest, which is obvious, a huge financial stake in not having to redo this trial now. They could lose counsel. They could have to hire new counsel because of things like that. And that would certainly be deleterious to any defendant, and all the more reason why it's important for us to cooperate to try to avoid any other errors in this case. But I don't regard this one as serious enough to justify a mistrial, because I don't think the defense is so seriously prejudiced. An instruction to the jury might be considered curative, and I would give one if the defense requested it. I am understanding that they do not want one, so I'm not going to give one in over their objection. So with that, I'll deny the motion.
Yes, my only remaining comments are then, I think we should move away from this topic. Obviously, the question of whether he understood the serious nature of the investigation has been already, that point has been made. But to then start asking questions again, eliciting that he had 3 days to think about it, or anything regarding.
Well, I would hope it wouldn't go into the 3 days business again, because we've already done it, and it would be cumulative, although it is cross-examination. She also managed to elicit that Mr. Rankine knew that Mr. Ellis had passed away at the time he gave the interview. All that stuff stays in.
That's fine.
I'm not sure. I guess you'll have to go on a case-by-case basis. We'll see what the question is. If it's objectionable, we'll sustain it. If it's not, we won't. All right, let's have the jury back. And Officer Rankine, if you would please retake the stand. Okay, that objection is sustained. Please, new question, Ms.
Mr. Rankine, at the time you gave your statement to the Pierce County Sheriff's Office, you understood that they were investigating the circumstances of Mr. Ellis's death, correct?
Yes, I did.
And you understand, they specifically asked you how long Mr. Ellis was prone, correct?
I believe so. You would have to show me.
You want to take a look? Do you have your statement there?
I don't.
I'm sorry.
Handing you back what's been marked as 65A.
Thank you.
You want to turn to page 31. At line 17, you were asked by Lieutenant Brockway. So it sounds like he was on his stomach during the fumble for a
I'm not
time.
there yet. Give me a second.
Is
What?
it page 31?
Page 31, line 17. So it sounds like he was on his stomach during the hobble for a time, rolled to his right side, and then back down to stomach, and then back to the right again. Is that right?
Hold on a sec. Well, he asked her to point out to him where in the interview's transcript it talks about that. So Ms. Eakes is fine doing this for the moment.
And you answered yeah, correct?
Yes.
And then he asked you, okay, and this may be hard to estimate, any idea how long he's on his stomach hobble? And you replied, I couldn't tell you, correct?
Yes.
And that's what you said back on March 6th, 2020, correct?
Yes, as in I don't have a specific time. I can't give you minutes and seconds of how long Mr. Ellis was in a certain position. But my independent recollection of it was that he was in a recovery position majority of the time.
But you didn't say that in March of 2020, did you?
It wasn't asked in that sense. I took it
You didn't
as
say it, correct?
I did not.
You said you couldn't tell him, correct?
I couldn't tell him specifically minutes and seconds.
Right. You were also asked in this statement specifically about your actions in terms of putting pressure on Mr. Ellis, correct? And you described all what you were doing, correct?
I believe so.
And in fact, if you take a look at page 19, you said to them, but you were talking about the
Can I get a
fire
second?
department.
Can I get a second real quick?
At line 11, you said, but they were already, I don't know, just a few blocks away from us, which I thought was really strange, you know, for fire to pull up on a scene and see numerous cop cars there, and then the just kind of rolling up all slow like to our scene. So at that point in time, I still had control of the guy's upper body. My right knee was around the right shoulder blade of him, and my left knee was on the middle of his back still. He was not thrashing around as much anymore. His head was turned to the left of his body. I did notice that his breathing was still the same. Was breathing I could see his chest rise and fall. And as fire was getting there, I made the decision to roll him back onto the subject's right side again, just because from my medical training and experience, that was the best position to put someone in. It's like the recovery position, is what they call it. Correct?
Correct. And what I'm trying to describe in the statement when it's being recorded is that I see fire turning from Pacific and coming down the hill, and I rotated him into the recovery position.
And then you were asked about the time that fire arrived at Mr. Ellis, or at the scene, correct? Do you recall that?
Yes.
Oops, I'll put the TV there. And you wrote up there, your counsel wrote up there that fire arrived at 23:33:09, correct?
Yes.
And you were asked to read that from Exhibit 20.
I believe so.
We could take a look at Exhibit 24 again. If you want to take a look at page 3. And if you could blow up the section that says response times and mileage. What time does fire say that they actually arrived at Mr. Ellis's side?
23:34:41.
Okay, so let's put that up there. 23, what is it? 34?
41.
So that's actually the time that fire was in contact with Mr. Ellis, right?
I believe that was testified to, yes.
All right, so in terms of the 8.5 minutes, that didn't take into account the minute and 30 seconds that it took for them to actually get to Mr. Ellis and take care of him, correct?
Correct, but I don't know how I would have been able to control that.
Now, you were asked about the CAD. Sure. Now, you were asked some questions on cross about the prior stop, or excuse me, on redirect, I believe, or one of the other crosses. Could you take a look at what's been marked as Exhibit 13? Handing you what's been marked as Exhibit 13.
I think that'd be on the scope when we're asking questions about the first stuff.
I don't know what you're going to ask. Go ahead and ask your question.
This is the CAD that relates to the prior stop that you backed up Officers Ford and, Officers Collins and Burbank on, correct?
Yes.
And that contains the same kind of information as Exhibit 17, is that right?
Yes, I believe so.
And it's recorded in the same way?
I believe so.
And this is something that you rely on as officers, correct?
Yes.
And in fact, this CAD documents what time you cleared the scene with respect to the backup call, the prior stop, correct?
You asking me what time I cleared this traffic stop?
Does it have the time on it that you cleared the traffic stop?
I believe this was testified to last this time. So why are we doing it again? Especially as counsel claims it's outside the scope.
I'm sorry, I was just asking this, whether it contains that time. Not, I wasn't gonna ask him about the time, but I would offer Exhibit 13.
Well, yes, you are. Anyway. Is there an objection to that?
I don't think it's
All right, 13 is admitted.
Thank you. And that does contain the time, the time that you listed, that you had cleared that prior stop, correct?
I did not clear that stop, so I would believe, yes, it is listed on here.
You were asked questions yesterday by defense counsel for Collins about how it would violate policy to remove handcuffs from Mr. Ellis. Do you recall those questions?
Yes.
And you said that it would, correct?
Yes.
Do you understand the questions I was asking you were about whether you could have released the hobble from the handcuffs, meaning just keep the hobble on but release it from the handcuffs?
I don't really know how the hobbles work, so I couldn't answer that question.
You didn't know how to release the hobbles from the handcuffs?
I mean, I could have, but that could have defeated the purpose of the hobbles, so I don't know.
Well, his feet would still be bound, correct?
I don't know how it works.
Did you see that the hobble was wrapped around his feet in order to keep his feet from being able to move?
I did not see, I think I explained in my testimony, I did not see the hobble being applied. I saw the hobble, but I don't know how it's used.
Right, but when the hobble was on Mr. Ellis, did you see that it was cinching his feet together?
No, I did not.
You never saw that?
I never looked back to his feet.
Well, you would agree that there's nothing in the TPD policies that would have prohibited you from releasing the hobbles from the handcuffs, is there?
Well, I don't know. I don't know. It's already been testified to, and maybe there's a dispute about this, but I don't think so, that the word hobbles doesn't appear anywhere in the policy, right? So by definition, it's not going to say anything about it. Am I missing something? So the issue was, is there something out in the policy which says there are some extra policy kinds of steps that officers can take, right? That's another aspect of this, but that wouldn't be in the policy, and that would presumably be one of these things. So I'm not sure it's a fair question. Obviously, by definition, it wouldn't be in the policy. Am I missing something?
I'm responding to the questions that were asked about
Well-
the policy violation yesterday, and that's what I'm asking to establish.
And you can, but with respect to actually talking about what's in that policy, why would you can ask about what would be wrong about that, and so on, or what he meant by it when he responded to the question. But specifically asking about the policy, it seems to me.
Hobble from the handcuffs, is that?
I think, like I answered yesterday, there was fear and risk that he may start fighting again.
even after Mr. Ellis had stopped responding to you?
When you say stop responding, as in he did not really talk to us the whole entire time. So
Correct, and he didn't move. He wasn't moving at a certain point, correct?
Well, I'll allow this at a certain point. I'm not sure what you mean by that, because he did say there was a time where he stayed calm and then started struggling again. Do you mean after that?
Yes.
I mean, you can ask him, if you narrow it down to after that, I think that would make some sense.
Let me ask you a better question. Is there any reason you couldn't have taken the hobbles and connected them to the front to Mr. Ellis's handcuffs instead of behind him?
I don't think that's possible. I don't know how that would work if his hands is behind his back.
I'm sorry, I didn't hear the end.
I said I don't know how it would work if his hands is behind his back. You can't.
Could you have moved the handcuffs to the front?
It's not something I have ever done.
So is it your testimony that because you're not familiar with the hobbles, you weren't able to think of other ways that you could have changed the hobble around?
Yes.
Well, his answer was not about the hobbles specifically. He was saying, how do you move somebody who's been handcuffed behind their back to their front? And I think the only way to do that is to unhandcuff them, right? And I think what he's saying is his experience is he doesn't do that or hasn't done that. That's independent of the hobble. If you want to ask about the hobble too, that's fine.
In terms of your testimony, do you recall being asked by Mr. Burbank's counsel or Mr. Collins' counsel whether or not Mr. Ellis was alive for 30 minutes after his client helped restrain him? Do you recall being asked about that?
Yes.
And you said that he was, correct?
Yes.
And you would agree that fire arrived at Mr. Ellis's side at 23, 34, 41?
Yes.
And it was only moments after they arrived that they told you that Mr. Ellis was going to code, correct?
Code as in
He
his.
was going to code?
Yes.
And you understood that to mean that he could die, correct?
Possibly.
He was at least going to need CPR, correct?
Yes.
You understood at that point that Mr. Ellis's health was, or his ability to survive was, he was in critical condition, correct?
I think Lieutenant Wilson testified that his medical status was declining.
And I'm not asking you about Lieutenant Wilson's testimony, I'm asking you about what you recall.
That's what I recall, that his medical status was declining. Yes.
You understood that Mr. Ellis was in critical condition when fire arrived, correct?
He misstates his answer. He said he understood it to mean that he was declining. And then you've restated it as your testimony this, which is not what he said.
Is it your understanding that only his condition was declining and that he wasn't in critical condition?
I don't know what you mean by critical condition.
Now, you were asked by Officer Burbank's counsel about how you were talking to Mr. Ellis throughout the contact with him, correct?
Yes.
And that you were checking on his well-being,
Yes.
but he never responded to you, correct?
Besides the I can't breathe? No.
And during all of the times that you were speaking with him, you never noticed that he was wearing a spit hood on his head, correct?
I think I previously testified. I know the spit hood was put on him at some point in time. It's just very vague in my memory of when and who put it on.
But didn't you testify yesterday that you didn't notice the spit hood until fire was triggering it?
That would be consistent with what I just said, as in it's vague when the time is.
It was after fire arrived.
Yes.
I can have just a moment. That's all, thank you.
Mr. Pritchard? Mr. Oster?
Good, sir.
Ms. Weeks just suggested now additional alternatives to what she suggested yesterday, right?
Yes.
Using hindsight, that's not allowed under the case law, right?
Yes.
I'm going to object, so it's argumentative.
Asked for an opinion of law about this, so I'll sustain the objection.
Understood. What she just suggested, and when I say that, meaning to detach the hobbles from the cuffs that are behind the back, uncuff Mr. Ellis, recuff him in the front, and then attach the hobble cord to the front, a reasonable alternative in this situation?
At that time, no.
Have you ever seen anybody do that?
No.
Have you ever been trained that that's even a viable option?
No.
Are there greater risks to Mr. Ellis, to the officers, and to the community if you were to do what Ms. Eakes just suggested you do?
Absolutely.
What could happen?
He could fall. He could, once you take him out of handcuffs, I've had multiple people just start fighting once they're out of handcuffs. I mean, it's,
I want to follow up on the timeline Ms. Eakes wrote in. She added 23/25/25 as to when Lieutenant Wilson arrived on scene. Do you remember her adding that to the timeline?
I'm gonna object that that's not what I wrote.
It was at the patient, but on scene.
Oh, sorry.
Well, that's not the right time to decide it.
Oh, I'm sorry. It's 23, 34, 31. You see that?
41. You need your eyes closed.
I see it, yes.
Do you remember her asking those questions? She added an additional minute or so to the time frame
Yes, sir.
from the time fire arrived, meaning at the location, to the time a medic got to Mr. Ellis, right?
Yes, sir.
If I understood your testimony when Mr. Conrad was asking you questions, you turned him over into the recovery position when you saw that truck coming down off of Pacific Avenue, right?
Yes, sir.
So she's just added another minute of time in which you had him in recovery prior to Lieutenant Wilson getting there, isn't that
I'm
right?
not gonna object that that's argumentative.
Oh, overruled up per minute.
Well, that's factually accurate, right?
Yes, sir.
Then she asked you about whether or not it was accurate to suggest or answer yesterday to my question that Mr. Ellis was alive for more than a half an hour after Officer Collins was relieved. Remember me asking that?
Yes, sir.
You agree with that?
Yes, sir.
It's actually longer than that, isn't it?
I believe so.
He was dead at 12:20 in the morning, wasn't he?
Yes, sir.
Not when medics arrived at 23:34:41.
Yes, sir.
I don't think I'll start.
Let me just a second here. Okay, go ahead, Mr. Conrad.
Officer Rankin, who did you ask for permission to remove the cuffs after fire had arrived?
Sergeant Lim.
No further questions.
Further cross?
No, thank you.
Mr. Pritchard? Mr. Esser? Okay, you can step down. Thank you. Next witness.
Your Honor, we need to bring up the matter outside the press.
Okay. It's about 9 minutes to noon, so we'll probably break for lunch as well. So see you back all later. Ladies and gentlemen, please do not discuss the case. Please do not view any report on the media in this matter.